Good evening. I'm Gillian Hnatiw, and I'm a lawyer who's been advocating for survivors of sexual violence for almost 25 years. When the verdict in the Hockey Canada trial came down last summer, there was a loud public outcry, rage, despair, frustration, followed predictably by calls to reform the criminal legal system. Well, I share the public's despair in many respects and certainly grieve for what happened to EM, the victim in that hotel room. I did not join, and I do not join, in calls to reform the criminal legal system. 9 years ago, as Lucy de Couture's lawyer, I was in the middle of the public backlash to the Gillian verdict. In the aftermath, at that time, I despaired at the way that Lucy and the other complainants had been treated by the criminal system. I believed it could be improved and was committed to working for reform. In the years that followed, Parliament enacted many changes to the criminal code, all of which were aimed at improving the system's response to survivors of gender-based violence. What the Hockey Canada verdict has showed us is that it hasn't made much of a difference. EM, the victim, may have been treated better by the Crown in the lead up to the trial. She was better prepared, her lawyer was treated with more respect, she was given more information about the process. But the trial itself and the outcome were the same. What's changed for me in the intervening 9 years is my perspective on what within the legal system needs to change to better address the harms faced by survivors of gender-based violence. When it comes to sexual assault, Canada's criminal system does what it is constitutionally designed to do. It weighs evidence in a grossly unbalanced way to guard against the risk of wrongful convictions. If you are a victim of sexual violence and you go to the police to seek justice, here's what awaits you. You will be a stranger to the process. You are not a party, but a witness. You will not be allowed to have a lawyer who speaks for you in court. You will receive very little, if any, information about what is happening with the case over the years that it winds its way through the court. You will not have any real say about whether the Crown takes it to trial, whether they plead it out, or whether they withdraw the charges altogether. You will have very few choices and even less control. You will absolutely be expected to testify. You will undergo lengthy cross-examination, often over several days. The accused, by contrast, does not have to testify. The entire process can unfold without him ever saying a word. Criminal trials are often described as he said, she said processes. But I think that's hugely misleading because most of the time he doesn't say anything at all. At the end of it all, the evidence before the court will have to satisfy the judge that the accused is guilty beyond a reasonable doubt. That means that a judge may believe you and even accept that your allegations are likely true, but may still not be satisfied beyond a reasonable doubt. In that case, the accused will be acquitted and walk free, and you will feel disbelieved. As long as the criminal system continues to work the way it was constitutionally built to work, the majority of sexual assault prosecutions will end in acquittals. It can't be fixed because it's not broken. It does what it was designed to do. I don't have time to engage with the question of whether sending perpetrators to jail make any of us safer. What I do want to talk about is alternative pathways to accountability and justice for survivors of sexual violence. My practice focuses primarily on civil remedies for sexual assault survivors. either through lawsuits or through human rights tribunals. When victims choose to sue their abusers and possibly the institutions that empowered or protected them, then they are engaging in an entirely different system, and many things for them will change. As the victim becomes the plaintiff, they will have a lawyer at their side throughout their the entire process who will advocate for them, take their individual goals and experiences into account, and afford them control over the process. They will be in the driver's seat. There is no right to remain silent in the civil system. The defendant will have to respond to the allegations against them and submit to multiple hours of questioning, all before the court goes to trial. The outcome is not black and white. 95% of cases resolve before even getting to the door of a courtroom. If done well, civil processes can re-empower victims and help heal old wounds in ways that neither jail sentences or even money ever can. I often say that sexual assault is not a crime of passion, but power. And in order to heal from the stripping of that power, you need to rebalance the scales. I've had more than one client tell me over the years that they feel transformed by the process, that it has allowed them to take back the power that was stripped from them all those years ago and regain their strength. So fabulous. Lawsuits are the answer, right? What if your assailant has no money? What then? If you're in Ontario, that's probably the end of your legal options right now. But that was not always the case. There's been a lot of chatter in the aftermath of the Hockey Canada trial about creating alternative legal systems for survivors centered on concepts of restorative justice and transformational justice. I'm all in favor of those conversations. But what many people forget or perhaps never knew is that until 2021 in Ontario, we already had a system like that. For more than 40 years, Ontario had something called the Criminal Injuries Compensation Board, which went by the acronym CICB. The tribunal's mandate was to award compensation to victims of violent crime, including sexual assault. To apply to the tribunal for compensation, all you had to do was complete a detailed application. It took some effort, but the process was straightforward and could be navigated without a lawyer. The CICB would then hold a hearing in which victims of sexual violence had the opportunity to tell their stories to neutral third parties and to be believed by people who had no obligation to believe them. There was no obligation or requirement to report the crime to the police. There was no requirement to secure an underlying conviction. CICB hearings centered the harm to the victim and looked at ways to compensate for them. Survivors could be awarded up to $20,000. This money enabled many individuals to secure safe housing, go back to school, pay down debt they had incurred while recovering from the psychological impacts of an assault. It wasn't life-changing money, but for many it was life-restoring money. In addition, the board made awards for private therapy that enabled individuals to choose a therapist in their community that they trusted and could form a therapeutic bond with. The system held no direct consequences for perpetrators, and sometimes that's fine. The tribunal centered harm to victim and concentrated on how to compensate for it. The whole process took 6 to 12 months. It was funded almost entirely by the victim's surcharge that is paid by individuals when they are convicted of crimes. I could not support any data to support this theory, but it is my very strong belief that the Criminal Injuries Compensation Board paid for itself by helping survivors to heal and get back to work or to school or to their families and to function again in society, thus diminishing their reliance on other forms of social assistance and getting back to work, which is what so many governments want us to do. Tragically, and I do mean tragically, the Ford government dismantled this tribunal in 2021. I have no explanation for this decision. It's never adequately been explained, and in my eyes, it's indefensible. So as public attention returns to questions of how to reform the legal system to better serve survivors of sexual violence in the aftermath of the Hockey Canada verdict, let's not repeat old mistakes and focus exclusively on the criminal system again. It's not broken. It's doing what it's designed to do. Instead, let's learn from our past successes and resurrect systems that worked to center the harms of survivors and compensate them for what they endured. Thank you.